It's part 4 of criminal law. And battery. Battery is unlawful application of force to another person, which causes bodily harm or constitutes offensive touching. Unlawful. It may include excessive use of force by an officer. Explicit and/or implicit consent is a defense. Aggravated battery may require a greater penalty, and this includes serious bodily injury inflicted and/or caused by the use of a deadly weapon. Looking at assault, an assault is an attempted battery or the intentional apprehension of imminent bodily harm. This requires the absence of contact, because if it is contact, it goes to battery. Apprehension must be reasonable, as above in battery. Aggravated assault may include a greater penalty where a deadly weapon is used in creating the apprehension of immediate bodily harm or attempted battery. Looking at kidnapping. Kidnapping is the unlawful confinement of the victim against the victim's will, and either movement or hiding of the victim. So you either have to move the victim or hide the victim. Looking at confinement of the victim, this is freedom of victim's movement must be significantly restricted against victim's will. You consider confinement by force, threats, or by fraud. In regards to movement or hiding of the victim, movement may be a short distance. So you move the victim a short distance, such as from the passenger seat to the trunk of the car. That's sufficient. However, if it is in commission of another crime, more movement than required for commission of that crime is required for D to be liable for both of them. Again, false imprisonment. This is unlawful confinement of the victim without consent, and confinement again can be by force, threats, and or show of force. Now, rape is unlawful sexual intercourse against the will of the victim by force or threats of immediate force. Now, this force requirement is removed by most modern statutes, so it's unlawful sexual intercourse, and again, threat has been removed by most modern statutes. For a rape to have occurred, penetration is required, emission is not. Now, intent is negated if the defendant reasonably believes the victim's lack of resistance indicates consent. Again, because rape is a general intent crime, requiring only intent to commit intercourse without her consent, if the defendant reasonably believes the victim's lack of resistance indicates consent, that negates the intent, and it's a defense. Moving on to inchoate crimes, and an inchoate crime is an unripened crime where the intended crime need not be committed. This includes solicitation and conspiracy and attempt. Looking at solicitation, this is the enticing, encouraging, and or advising of another to commit a crime. Now, the crime need not be committed. Solicitation is completed upon the encouragement. If the crime is committed, parties may be co-conspirators. Now, under the common law, renunciation is not a defense. Under the model penal code, renunciation is a defense, but it must thwart the crime. Looking at conspiracy. Conspiracy is an agreement between two or more parties to accomplish an unlawful purpose, and the intent to accomplish said unlawful purpose. Unlawful purpose is criminal conduct. Now, agreement can be inferred from the actions. Majority of jurisdictions, an overt act in furtherance of the conspiracy is required. This is the federal rule and also the rule in the majority of states. Under common law, no overt act is required. The conspiracy is completed at the point of agreement. But that's the minority. Majority rule of states and the federal rule is the overt act. An overt act in furtherance of the conspiracy is required. And the Pinkerton rule under conspiracy is conspirators are liable for both crime and crimes by co-conspirators in furtherance of the conspiracy. The impossibility to complete intended crime is not an offense. Withdrawal, a majority of jurisdictions in the federal rule is withdrawal is a defense if communicated to co-conspirators or police. Under common law, again, it is not a defense, because the majority requires an overt act. The common law does not. Looking at attempt, you have a substantial step towards a crime and the specific intent to commit the crime. If completed, attempt merges with the crime, like an attempted battery and a battery. If you attempt a battery and you succeed in making contact with that person, that is a battery. The attempt merges with the battery. Mere preparation is not a substantial step, but conduct that tends to effect commission might be, such as possession of specialty materials, lying in wait, searching for the victim. And that completes part 4 of criminal law.